Hello, and welcome to the seventh episode of Raising Capital 101, where we will discuss the in and outs of raising capital, what to do and what not to do if you're planning to get some investors interested in a project of yours. I'm Tom Voekler, and I'm joined today by my colleagues John Watson and Mehanna Borostyan. Today, we'll do a deeper dive into Rule 506 offerings under Regulation D. On the last episode, we briefly touched on some of these topics, and we're going to delve a little deeper. John, do you want to tell us how 506 works as an exemption from regulation under the Securities Act of 1930?
Sure. So the Rule 506 Safe Harbor exemption is under Reg D under the Securities Act. And like the other exemptions from Securities Act registration, there are requirements, there are pros, and there are cons. So one of the requirements is there is a limitation on the type of investor from whom you can take investments under Rule 506. And there's two flavors of 506, 506B and 506C, and we'll talk about each one. But under each, you can have an unlimited amount of accredited investors. Under 506B, you can also have some non-accredited investors, and we'll get into that. Another requirement of Rule 506 is you have to provide the type of information you would normally provide in a prospectus for a registered offering. And the way we handle that, and a lot of issuers handle that, is through a private placement memorandum that mimics a prospectus that you would have under a registered offering. So I already mentioned some pros are you can have an unlimited amount of accredited investors, you can raise an unlimited amount of money, and one of the cons is you're going to have restricted securities, or the investors will have restricted securities. So there are some significant limitations on resale. And I think I'll leave it at that.
So one of the requirements to have a successful 506 is to file a Form D, which basically you file with the SEC and with all the states, and is the notice by which states are notified of your filing. Mehanna, how onerous is that, and basically how does it work?
Sure. So the Form D that goes to the SEC is filed through their online database called the Electronic Data Gathering, Analysis, and Retrieval System. Everyone refers to it as EDGAR. In order to file that Form D, the issuer will just need what we call a filer identification number, a password, and the actual Form D itself is pretty basic. It requires pretty basic information about, executives at the company, the name of the issuer, the type of securities offered, and the amount of the securities offered. So that is actually pretty easy to file and go through. The state offerings are the same, right? You're filing the same notice across states, but it is onerous in that you have to file with all of the states, and usually you have somebody who goes through and make sure that it's filed on time. There's also a timing element to that. So within 15 days of the first sale of securities in the offering based on the exemption, you have to file that Form D through the SEC. And so the SEC kind of defines that as when the first investor is contractually committed to invest. So when you receive that subscription agreement and accept that subscription agreement, you have 15 days to file that Form D, and that's taken pretty seriously.
Oh, the NASA, which is the association of all the security examiners, they've tried to make this a little bit easier through an online payment portal, right?
Yeah, they've tried to make it a little bit easier, a little bit more streamlined. Each state still has their fees that issuers have to pay, and so that can add up when you're going across 50 states. But yeah, it's pretty streamlined in the process. It just requires some forethought on the part of the issuer and some attention to the timing of when you're accepting that first investment.
So, John, some of these Reg D offerings, these private placements, might go on for quite a while. Are there any updating requirements with a Form D?
Yeah, there are a few. So first, if you make a material mistake in your Form D or there's a material change, you'll need to file an amendment to fix that. So if you want to, say, materially increase the amount of securities you're offering, you'll file an amendment for that. Also, if your offering continues for more than a year, on that 1-year anniversary of the date you first filed the Form D, you will need to file an annual update. And on the annual update, you'll need to go ahead and bring all the information up to date. Even if you wouldn't have had to file an amendment, it wasn't a material change, nonetheless, at your annual update, you will need to bring all the information on the Form D up to date.
That's great. So one of the reasons you do file 506 is that you have a federal preemption from state regulation of the offering. So that leaves the states out of making you register or follow one of their procedures. But Mehanna, do state regulators ever comment on a Form D filing?
They do. And we were just speaking about this, that especially with 506B offerings, the state regulators can go and look at the issuer's website and the available social media and the marketing material that they can access to make sure that you aren't conducting general solicitation. Because if you are, you're in violation of that rule, and they have, jurisdiction over that, and can come after you for that.
It's interesting. I will not name the state regulator, but had dinner with one, and he informed me that they would hire interns solely for the idea of looking at Google. They would Google any Form D filer that came through and see what's out there on them. And they would look for, was there any type of deceiving marketing being used back when it was just 506B? Was there any general solicitation? And it's the regulators' way, because they always have a fraud claim in their state, to kind of make sure that these offerings are still meeting their expectations. So, John, last webcast, we talked a little bit about this, but what is kind of the accredited investor standard that most people, a regular investor, would fall under?
Yeah, so the accredited investor definition, you'll find that in Rule 501 of Reg D, and that is updated periodically by the SEC. And there's different flavors. There's entity accredited investors, and I'll talk a little bit about individual accredited investors. And there are two ways you can qualify as an individual. Maybe some more with licenses, but two primary ways. One is based on assets, and that looks at your net worth, your total assets minus your total liabilities. And your primary residence does not count as an asset. And there's some more rules with respect to that. And a way that an issuer can test for your net worth, they could look at your account statements. They could do a credit report to see what your liabilities are. They might need you to confirm your liabilities to make sure there's nothing missing from your credit statement or your credit report. So that's assets. And then you can also qualify with your income. So an individual with gross income exceeding 200,000 in each of the two most recent years, and an expectation of that same income in the current year. And for couples, for spouses or spousal equivalents, the number jumps up to 300,000, and the same yearly requirement. And to verify your income, that's pretty easy. You can look at tax returns. So those are the main two ways an individual would find themselves in the definition.
Mehanna, we talked about this a little bit last time, but there's a laundry list of what the SEC considers accredited investors. You want to tell us about a couple of the other ones?
Sure. So entities with 5 million or more in total assets, corporations, partnerships, LLCs, trusts, family offices. There's a whole swath of entities that can fall into that category. And then certain financial entities, so banks, insurance company, registered investment companies, those types of companies that are kind of already subject to some of the financial literacy that you would expect that they would be able to invest in an unregistered offering. Those are also swept under that definition. Like John said, it's defined in Rule 501. There's quite a few exceptions, and most issuers will include that kind of definition in their who can invest or who may invest section in their PPM, and then that's how you fall into that accredited investor designation.
Yeah, excellent. John, a lot of people, are putting these types of investments as part of like their estate planning, and so when they think about it, they're looking at, do these come from self-directed programs? Are the individual investments? And a lot of people will set up trusts. How to trust specifically, because we do spend a lot of time with our clients. They ask us, is this trust accredited? What are some of the tests?
So there are a few ways that trusts can qualify as accredited. The first has kind of three parts. They have to have more than 5 million in assets. The trust was not created to invest in the private offering. And the person directing the trust investments needs to be a, quote, sophisticated person, unquote. And that's kind of its own definition we've talked about before. So that's one way. Another way is if the trustee of the trust is a bank, a registered investment advisor, or certain other registered entities. And then there are some more nuanced ways that a revocable trust and an irrevocable trust can qualify. So for a revocable trust, each grantor of the trust needs to be an accredited investor. And, because it's a revocable trust, they need to be able to amend or revoke the trust. And then for irrevocable trust, it looks a little bit more at the beneficiaries and their qualifications as being accredited. But those two flavors of accreditation are based on SEC no action letters. So those are a little more fact specific and will probably require a little bit more analysis than your standard accredited investor definitions.
A question we get all the time, Mehanna, is that's great. Love that I can offer this to accredited investors, but I've got this pool of people I know that are not accredited. Can I just offer this to them? How does that work?
So if you're conducting a 506B offering, you can accept up to 35 non-accredited investors, and it's subject to some restrictive requirements. So they have to have that sufficient knowledge and experience in financial and business matters to be capable of evaluating the merits and the risks of the prospective investment. That's kind of the standard baseline requirement for these non-accredited investors. And then on the part of the company that's conducting the offering, they have to make sure that the non-accredited investors have the same type of information that you would generally expect to see in something like a Regulation A filing. So all those disclosure requirements, they need to have access to financial statement information of the company, and they should be able to contact the company for information regarding the business, the securities, the offering in general. That should be a way that the non-accredited investors can protect themselves. So it is possible. There are restrictions on it, and it can only be done through 506B.
Yeah, so most of the time it's probably not practical, and our advice is that it's probably too hard to make sure that they have all the information required. But it is always a question we get. All right, we're going to kind of hit on our last topic, which is the difference between 506B and 506C, because it's pretty new that the SEC opened up a private placement to just general solicitation. So, John, you want to give us a kind of a brief discussion of the difference?
Yeah. So, Mehanna and Tom, you just both spoke on, the non-accredited aspect, and, we don't like doing that. So I'll just skip over the type of investor. The big change with 506C is the opportunity to engage in general advertising and general solicitation. So that's, a huge change going from 506B, where you have to pay very close attention to your marketing materials, your PPMs. You keep them numbered, you keep track of who you gave them to. Now moving to 506C, where you can engage in general advertising, and that just looks completely different. On 506C, you could put information about your offering on your website. You could put advertisements in the newspaper. You could go on social media. You could go on even like TikTok if you wanted to, and talk about your offering, and obviously can't, say anything that's not true, no material misstatements, etc. But it really opens up the floodgate in the way you can market your offering to the general public.
So does the SEC really care what medium you use, John? I mean, if I just, say something on a podcast versus something written versus an interview.
No, I mean, it's really up to the issuer with 506C. I mean, general advertising is really what it sounds like. It's up to you as the issuer how you want to go about marketing your offering. I kind of left out, there is you have to confirm that your investors are accredited, and we talked about that in the last episode. But the medium is really up to the issuer.
So Mehanna, I just decide to blast whatever I want, however I want to advertise. What's to stop me?
Yeah, I think that it creates. So in order to generally advertise, you have to take reasonable steps to verify that the investors in the fund are accredited investors. And that's not just a check the box, the investor says they're accredited and you believe them. The issuer is expected to take those reasonable steps. And so that can be, looking at W-2s, Form 1099s, if they're individuals and they're speaking to their income. You can look at bank statements, brokerage statements. And so there's a level of diligence that the issuer has to take on when you advertise in such a broad way that may stop some issuers from wanting to market in that way, just because it does kind of up the ante of what we need to look at in order to ensure these investors are accredited.
Yeah, no doubt. And then you always have kind of anti-fraud provisions, both at the state level and at the federal level, where you can't just say anything, right? It has to be fair and balanced. So you're always a little bit limited in what you can do, even though people don't believe they are. So that's going to end today's discussion. That was great. I'm sure we're going to have more that we need to discuss, especially with regards to 506B and C and how we go about advocating one over the other. But we hope we understand a little bit more about your options with 506 private placements. And you just got to remember that each situation is different, and how these rules and regulations apply to your specific offering can be really tricky, and they do require professional expertise. If you have any questions or suggestions for future episodes, please contact us. You can also visit our securities and corporate governance and REITs web pages at williamsmullen.com. There you can find out more about our team, as well as all of our legal alerts. And finally, be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening, and until next time.